Good day, doctor. My name is Satyarupini Bharathan. My metric number is S71721. Today I'm going to explain about summary of the case and also issue 1. Summary of the case. Ketapang Trading Co. is a Malaysian company that sells electronic products across the Asia. They made a big 5-year deal worth RM 150 million with Jamal Sanjar Bahad, which is a local company that makes a special electronical parts for electric vehicles. Ketapang first sent a request of proposal RFP with that they needed. Jamal replied with a memorandum of understanding, which is agreeing to the most of the part but adding some changes like 10% price increase and different delivery condition. There was some confusion, but Ketapang thought it was accepted, but Jamal said it was still under discussion. Later, both companies officially signed the contract at a public event, but the person from Ketapang who signed it was not authorized to approve such a big deal. However, Jamal didn't know about the internal truth. Before the signing, Ketapang's CEO received a blackmail email with the personal photos and threatening to leak them unless the deal with Jamal continued. He didn't report the incident until 6 months. Jamal also gave a false information during a negotiation. They said their product could work in negative 40 Celsius to positive 125 Celsius, but their own test result shows only negative 20 Celsius to positive 101 Celsius. It was important because Ketapang trusted information before signing the contract. About a year later, during a heavy monsoon rain, Jamal's factory was hit by a lightning and got fired. As a result, they failed to deliver an important shipment of 50,000 parts. This caused Ketapang to lose a major client and pay RM 7.9 million in penalties and also lost RM 25 million contract with another big customer. This caused reputation of Ketapang badly affected. Now Ketapang is suing the Jamal for misrepresentation and breach of contract, while Jamal is also filing a counterclaim. The first issue is Jamal Sanjar Bahad claims the operational temperature range of its semiconductor components constitute misrepresentation under Malaysian contract law, and if Ketapang Trading Co. is entitled to rescind the contract or claim the damages. The head of the case is Jamal's statement amounted to misrepresentation under Section 18B of the Contract Act 1950, giving Ketapang right to rescind the contract or claim the damages under Section 19.1 and 19.2. And the fact of the case is Jamal misrepresent the operational temperature range of its semiconductor, claiming negative 40 Celsius to positive 125 Celsius when it tested only supposed negative 20 Celsius to positive 101 Celsius, and Ketapang relied on this to enter the contract. Let's discuss about the law. The first one is Section 18B of the Contract Act 1950. Any branch duty which without an intent of beside give an advantage to a person committing it or anyone claiming under him by misleading another to his prejudice or to the prejudice to anyone claiming under him. Second law is Section 19.1 of Contract Act 1950. When the consent to an agreement is caused by coercion, fraud or misrepresentation, the agreement is contract voidable. The option of party who consent was caused. The third one is Section 19.2 of Contract Act 1950. A party of contract whose consent was caused by fraud or misrepresentation may, if it thinks fit, insist that the correction shall be performed and that he shall put in position which he would be FBN the representation may have been true. Now let's look at case law. Is Petroleum Co. P. Ltd. v. Mahjong. The fact about this case is involved ESO providing a forecast 200 gallons for petrol station to Mr. Madan, who was considering Tennessee. As ESO proposed a special knowledge or skill, they were planning to changes that significantly impact the potential throughput, but ESO failed to revise the forecast downwards. Mr. Madan relied on the forecast. One of the most important issues in this case is whether Jamal Sundran had representation of the operational temperature range of its semiconductor constitute misrepresentation under Malaysian contract law, and whether the Ketapang Trading Co. is entitled to resigns of the contract to the damages. The second one is misrepresentation across under Section 18B of Contract Act 1950, where without intent to deceive one party to make a representation that gives an advantage to itself as a mislead another party to its determined. Jamal assured Ketapang that its semiconductor could withstand a range of operational temperature between negative 40 Celsius to positive 125 Celsius, whereas its internal document had shown that its semiconductor components were only tested between negative 20 Celsius to positive 101 Celsius. It's clearly a misrepresentation, as Ketapang relied on that to enter the agreement. Following by the Electro Petroleum Co. Ltd vs. Madan is a useful case to consider here. In ESCO Petroleum, the court ruled that if the party has a unique expertise, any statement made by the party about a technical fact are likely to be relied upon by other party. If those statements were recklessly made, even the party making the statement believed it to be true, it might still amount by negligence, misrepresentation. Likewise, Jamal has a duty to check and verify its claim as a specialized manufacturer, while Ketapang has relied on those specifications with respect to high-performance electronic components. The misrepresentation was materially significant. In any case, the purpose of the discussion is that under Section 19(1), the Contract Act of 1950, Ketapang can void the contract by a reason misrepresentation. However, the section of 19(2) provide a second remedy. Ketapang could insist on perform of the contract and demand a damage of the equivalent of what was promised. In either case, if Ketapang pursued damage instead of rescission, then the court may order the compensation for the loss caused reliance on false specification. In conclusion, based on Section 18 and 19 of the Contract Act 1950, along with the applicable local jurisprudence, make it clear that Jamal's statement about functioning temperature range of its semiconductors constitute a misrepresentation. This occurred without fraudulence purpose, but it encouraged Ketapang to enter the contract. As a result, Ketapang has right to cancel and confirmation the contract and seek damage include relied on thought compensation. This remedy is implied supported by both statutory provision and case law.
Hi and Assalamualaikum, Assalam sejahtera. My name is Nurul Amira Syairah binti Hassan. My number matric is 7S70759. Today I'm going to present my part, which is the second issue. So based on ILA method, we're going to start with the issue. So the issue here is the contract between Ketapang Trading Co. and Jamal Sundran perhaps valid, and have possible despite by side representative who lack proper authority under Ketapang internal governance protocols. Next, we're going to move to the law. So we have 5 law in here in this issue. First is Section 2A of Contract 1950, Section 2B of Contract 1950, Section 10 of Contract 1950, Section 11 of Contract 1950, and the last one is Contract Section 140 of Contract Act 1950. So I'm going to explain three of them first. First is Section 2A of Contract Act 1950, which means offers, willingness to enter into an agreement. Section 2B of Contract Act 1950, acceptance, mean when the offer is agreed to occasionally a binding contract is formed. And second, and third, an agreement becomes contract when it is made with the consent by competent parties for lawful considerations and a lawful objects and is not otherwise declared void. Next, we're going to move on to Section 11 of Contract Act 1950. Every person is competent to contract who is of the age majority according to the law to which he is subject and who is of some mind that is not disqualified from contracting by any law to which he is subject. And the last one is Section 140, Contract Act 1950. An authority is said to be expressed when it is given by spoken or written. Authority is said to be implied when it is to be inferred from the circumstance of the case. And things spoken or written or the ordinary course of dealings may be accounted for in circumstance of the case. Next, we're going to move to the case law. I have two case law here, which is Hyde versus French 1840 and Chan Yi Ti versus William Jacks and Co. First, I'm going to talk about Hyde versus French. This case is about Wrench offered to sell his farm to Hyde for £1,000, stating it was his final price. Hyde responded with a counter offer of £950, which Wrench rejected. Later, Hyde tried to accept the original offer, which is £1,000, but Wrench refused to sell, so Hyde sued, claiming a contract had been formed. The legal issue here is whether Hyde counter offer had terminated the original offer, making it no longer valid for the acceptance. But the Hyde said the court rules there was no contracts. Hyde counter offer of £950 was a rejection of Wrench offer, which is £1,000. Once rejected, the original offer could not be revived unless Wrench made a new offer. So this case established that a counter offer terminates original offer. Next, we're going to move another case law, which is Chan Yi Ti versus William Jacks and Co. So the facts here is Mr. Chan and a younger person named Young registered a business called Chan and Young Tradings and operate as partners, including opening a joint bank account. During a meeting at the coffee shops with the suppliers named William Jacks and Co., Mr. Chan told the supplier representative that Young was his business partners. Based on this, the supplier gave quotes to Young, but Young failed to pay. Mr. Chan denied being part of the meeting, but the court found he was present and had confirmed the partnerships. So the issue here is whether Mr. Chan could have responsible for the unpaid goods due his conduct. Even so, Young was a minor and the partnership was not fully valid. Specifically, did Mr. Chan's actions amount to holding up Young as his agents or partners, creating agency by estoppels? So the helps here, the court rules that Mr. Chan were liable by representing Young as his partners and acting in a way that made supply believe in the partnerships. Mr. Chan creates the impression that Young had authority to act for the business. Under agency by estoppel holding out, Mr. Chan could not later deny the partnerships to avoid responsibility. He was legally bound by Young actions and had to pay for the goods. So next, we're going to move to the applications. Ketapang Trading Co. issues an RFP, which is considered an offer under Section 2A of the Contract Act 1950. Jembal responded in MOU proposing new term, making its counter offers not an acceptance. This application based on Section 2B and case law named Hyde versus French. So later, both parties signed a final agreement at the public ceremony, showing mutual concern and intention to create a legal relations fulfilling such terms. Although Ketapang Regional Director did not have board approvals, Jembal was unaware of this. His titles, the company conduct and former signing, create the appearance of authority. Under Sections 140 and the doctrine agency by estoppels based case law Chan Yi Ti versus William Jacks and Co., Ketapang is legally bound by the agreement. So the meaning agency by estoppel holding out is a person treated as having an agent because their own words or actions, even if normal agency exists. If you make it appear that someone can act your behalf and others rely on the appearance, you cannot later deny the authority. So this rule protects the parties who reasonably relies on what they will to believe. So now we're going to move to the last section in allied methods. The contract between Ketapang Trading Co. and Jembal Sedia Berhad is valid and enforceable under Contract Act 1950. Although Ketapang Regional Operation Director lacked actual authority under the company internal governance, Jembal was never informed of this. Ketapang conduct and participant in the formal signing ceremony gave a reasonable impression of authority, creating implied authority under Section 140. Reference to Chan Yi Ti versus William Jacks and Co. Malaya, Ketapang is stopped from denying debt authority. All essential elements of a valid contract were present over Section 2A, acceptance Section 2B, intention to create legal relations, and competency of parties Section 10 and 11. The early counter offers by Jombals did not invalidate the contract, as final agreement was later signed in line with the principles case law Hyde versus Ranch. Therefore, the contract is legally binding, and Ketapang Trading Co. is accountable for the agreement entered in Sedia Berhad.
Assalamualaikum warahmatullahi wabarakatuh. My name is Nurul Hafizah binti Sa'ad, issue number S61606. I will continue to present issue 3. This issue was related to the topic free concern. Legal issue of this case, the email trade received by Ketapang Trading Co. CEO aimed at pressuring contract finalization amount to economic duress under Malaysian contract law, thereby rendering the contract voidable. Next, for law, the related law first is Section 15 of the Contract Act 1915. Coercion is the committing or threaten to commit any act forbidden by the Penal Code or the unlawful detaining or threatening to detain any property to the prejudice of any person whenever with intention of causing any person to enter into an agreement. Next, Section 19(1) of Contract Act 1950. When consent to an agreement is caused by caution, fraud, or misrepresentation, the agreement is contract voidable at the option of the party whose consent was so caused. For the case law, Perlis Plantation Berhad versus Muhammad Abdullah Ain. The fact for this case, according to the defendant, he was under economic duress from the plaintiff when he signed loan documentation and a guarantee. The issue was Malaysian law definition of coercion in Section 15 of CA applicable to English common law concept of economic duress. And the help said no, precise and comprehensive definition of coercion, commit any act forbidden by the Penal Code, unlawful detention of property is given in Section 15 of the Contract Act 1950. Next application, whether the anonymous email received by Ketapang CEO threatening exposure unless the contract was finalized amount to economic duress under Malaysian law, thereby making the contract voidable. Under Section 15 of the Contract Act 1950, coercion refers to an act forbidden by the Penal Code or the unlawful detaining of property with the intent of forcing a party into an agreement. The threat received by Ketapang CEO involved reputational harm rather than directly physical coercion or detention of property. While this may constitute economic duress in other jurisdictions, Malaysian court have not recognized economic duress as a valid ground for avoiding contract. The ruling in Perlis Plantation Berhad versus Muhammad Abdullah Ain is particularly relevant. This case held an economic duress does not qualify as coercion under the Contract Act 1950, reinforcing that Malaysian contract law adheres strictly to the statutory definition of coercion under Section 15. Unlike English common law, which acknowledge economic duress, Malaysian court require physical coercion or unlawful detainment for a contract to be voidable. Therefore, Ketapang cannot void the contract on the sole basis of an email threat, unless direct evidence link Jembal to the coercion. Without such evidence, the contract remains enforceable, and Ketapang may need to rely on alternative claims such as fraud or undue influence under Section 14, which would require proof of international manipulation. In conclusion, according to the Contract Act 1950 under Section 15, the anonymous email threatening reputational harm does not certify the level of compulsion as interpreted by Malaysian court. Followed by the case of Perlis Plantation Berhad versus Muhammad Abdullah Ain state that the absence of physical threat or unlawful detention as needed by statutory definition and confirm means that economic duress, while recognized in other countries and has no validity under Malaysian contract law. However, Ketapang can present clear proof linking Jembal Sdn Berhad to the threat or demonstrate manipulation that rise to the level of fraud or undue influence under Section 14. The contract cannot be declared void. As a result, regardless of the circumstances surrounding the email threat, the agreement remains legal binding.
Hi, I'm Shiva Singh metric number 71479. The fourth issue of this case is whether Jembal's failure to deliver microprocessors due to a factory fire constitute a breach of contract, and if Ketapang Trading is entitled to claim damages for losses and reputational harm. The laws regarding this issue: first, Section 40, when a party to a contract has refused to perform or disabled himself from performing, is promised in its entirety, the promisee may put an end to the contract. Second, Section 57(1), a contract to do an act which after the contract is made becomes impossible or by reason of some event which the promiser could not prevent or unlawful becomes void. Third, Section 74, compensation for loss or damage caused by breach of contract. Moving on to case law, first, Conda with the Baronites. Facts: a technical agent contracted with the Baronites to employ drummer Tony Chapman, requiring him to perform 7 times a week. Before starting, Tony fell ill and could only perform 4 times weekly. The agent claimed the contract was frustrated. Issue: was the contract frustrated by Tony's illness? The court ruled yes. The contract frustrated because of Tony's illness, which made him unable to meet the essential requirement of performing 7 nights a week. This fundamentally changed the nature of the contract, making its original performance impossible. Second, Hedley with Brazilian. Hedley Smith's broken crankshaft were delayed by the courier Brazilian, causing losses. The courier is aware that the mill stopped, but not the crankshaft is essential for operation. Issue: whether Brazilian was liable for Hedley's lost profits. The court ruled damages can be recovered only if they naturally arise from the breach or were specifically communicated by both parties at the time the contract was made. Bazendale was not aware that the mill's operation was dependent entirely on the crankshaft, so Bazendale is not liable for the lost profits. Moving on to application, the case mentions frustration arises under section 57.1 when Jamal fails because of fire due to lightning. The effect of frustration arises only in cases where performance is objectively impossible. In this case, the failure to protect against lightning by the way of such protection, storage of flammable materials, and so on shows possibility and preventability. Accordingly, we are dealing with breach of contract under section 40 and hence entitled Ketapang to damages for the default under section 74. The losses suffered by Ketapang, minimum liquidated damages of 7.9 million and 25 million for loss of contract should be recovered according to Hadley v. Bazendale. Because of these damages flowed naturally because of the breach and were within the contemplation of the parties given the high profile stage of the EV supply chain. To conclude, under section 57.1, because the event was neither unforeseen nor completely beyond the preventive control, Jamal's failure to perform due to factory fire did not meet the condition for frustration. Jamal had shown negligence rather than true impossibility due to lack of suitable measures, which offend section 40. As a result, Ketapang Trading Co. is entitled to claim damages under section 74. Using the principles of Hadley v. Bazendale, both the 7.9 million ringgit in liquidated damages and the 25 million ringgit lost from the miscontract should be recovered as both losses were reasonably foreseeable and within the knowledge of both parties at the time the contract was signed.
I present issue 5, which is a deal with a whether an exclusion clause in a supply contract adapting is available statutory warranties under the Consumer Protection Act 1999 and the Sale of Good 1957 is legally valid and enforceable under the Malaysian law. Firstly, let's look at relevant legal provisions. First, Consumer Protection Act 1999, CPA. This act generally prohibit contracting out of its provisions, especially when it's come to consumer goods. So any attempts to waive consumer protection is likely invalid. Second, Sale of Good Act 1957 SOGA Section 20 implies conditions and warranties into contract for the sales of goods such as fitness for purpose and measurable quality. Third, Contract Act 1915 Section 29, while not directly about exclusion clause, is a agreement restraining legal proceeding, void, reflecting a wider principle that restricting a legal right is against a public policy. Application to the current issue. So how does this apply? If a clause tries to exclude protection under the CPA or SOGA, Malaysian courts will likely find it void, especially in consumer contract. Courts have consistently upheld that public interest and consumer protection cannot be contracted out of the clause even if agree upon will not be enforceable because it undermines basic legal right. In conclusion, referring to the case of Matang Plastic and supported by the principle in CPA, SOGA and the Contract Act, exclusion clause that seek to remove statutory protection are unenforceable in Malaysia, particularly when the goods serve the public interest such as electric vehicle. This protect consumer and ensure that businesses cannot avoid their legal responsibility just by inserting a clause into the contract.
The sixth issue is whether the exchange of documents between Ketapang Trading's RFP and Jamal's MOU constitute a valid offer and acceptance, thereby forming a legally binding contract under Malaysian contract law. Facts. Ketapang signed an RFP and Jamal responded with MOU that included new terms, making it a counter offer, but a binding contract was only formed after the formal agreement was signed at a ceremony attended by both parties, held under Malaysian contract law and supported by Loh Yaqin with Mod Isa. The final agreement confirmed a valid offer and acceptance, making the contract legally binding despite earlier informal exchanges.
So hi again. So in this issue we have 4 law, which is section 2A, section 2B, section 7A and section 10. So section 2A is when one person signifies to other his willingness to do or to do abstain from doing anything with a view to obtaining the assent of the other to the act or abstinence he say is to make a proposals. Meanwhile, section 2B is when the person to whom the proposal it makes signifies his assent. The proposal is said to be accepted. A proposal when accepted is become a promise. So section 7A, in order to convert a proposal into a promise, then acceptance must be absolute and unqualified. The last one is section 10. All agreements are contract if they are made by pre-consent for a lawful considerations with a lawful objects and are not hereby expressly declared void. Okay, next we're going to move to the case law. We have Ross and Franco versus TR Crompton and Bros Ltd and Loh Kai and Ross versus Muhammad Isa and Anwar. So we're going to talk about first case, which is Ross and Franco versus TR Crompton and Bros Ltd. So the facts here is Ross and Franco versus TR Crompton and Bros Ltd had written a contract for the sale of paper goods. There was a clear statement in this agreement that it was not a formal or legal agreement, that it was not subject to court pleadings. Rather, it was honorable pledge due to his agreements. Ross and Franco do the disagreements. Ross and Franco filed a lawsuit alleging breach of contract. So the issue here is, was the agreement between the parties legally binding contract, given the clause explicitly denying the intention to put legal relations? So Hess said, no, it was not legally binding. The honor clause showed that both parties has intention to create legal relationships. So now let's move on to the low credits and Ors versus Muhammad Anwar. So the facts here, his defendants gave plaintiff agents an option to purchase the land. The option states subject to formal contract by drawn ups and agreed between parties. The plaintiff agent exercised the options, but the defendant refused to sign the contracts. The plaintiff sued for a specific performance or damages. So the issue here is, did the option exercise, which was subject to a formal contract, amount to binding agreement for the sale of lands? So the head said, no, the contract was legally binding because the contract was not legally binding because it was subject to a formal contract. The option only represented an agreement to enter into a future agreements. It lacked the requisite intent to establish immediate legal relations.
Next, I will continue for the application for issue 6. Ketapang Trading Co's request for proposal RFP is an invitation to trade and not an offer. Jembal Sdn Bhd Memorandum of Understanding MOU on new term such as price volatility does constitute a counter offer and not an acceptance under section 7A of the Contract Act 1950, which require acceptance to be absolute and unqualified. No contract was made binding at the MOU stage, in line with the rule in the case Low Kharjit and Ors versus Muhammad Isa and Anner, that primary agreement conditional on a formal contract agreement to agree, lacking immediate legal intent. The final and legally binding contract was only established when the formal agreement was executed at the ceremony, because the act clearly signified that the parties freely offer acceptance and possessed a clear intention to create the legal relation, nullifying all the informal exchange that had occurred prior to it. Next, for the conclusion, according to the Contract Act 1950, Section 2A, 2B, 7A and 10(1) that state a clear offer, absolute acceptance, mutual consent, lawful consideration and the desire to form legal relation which related to the statement of Ketapang Trading Co. and Jembal Sdn Bhd. Initial RFP and MOU that indicated primarily conversation rather than a binding agreement, that also related to the case Low Kharjit versus Muhammad Isa, where an agreement subject to a formal contract was not enforceable. However, the final contract was demonstrating a strong intent to be legally bound and properly signed at the ceremonial gathering. Furthermore, despite earlier uncertainties, the written contract between Ketapang and Jembal is legally binding based on the principle established in Ross and Frank Co. versus J.R. Comprompton and Ross Ltd, where commercial agreements are believed to be enforceable until specifically excluded.